Let me ask you something most families don't realize until it's too late. What if you're told you inherited a house, but legally you don't actually own it yet? And what if one missed document or misunderstood probate step could delay the sale for months? Or worse, cost the estate tens of thousands of dollars? Well, today I'll show you what most people get wrong when selling a home in probate and how you can avoid these expensive mistakes. Welcome back to California Probate Real Estate Made Simple, where we break down probate real estate and the probate process in plain English so you can move forward with confidence. First, let's clear up a major misconception. Selling a home in probate is not the same thing as selling an inherited home. In a probate sale, the deceased person is still technically the owner and on title. The home does not belong to the heirs yet. The probate court must appoint a personal representative, either an executor or an administrator, and only that person has the legal authority to sell the property. So today, I'm going to walk you through the ultimate probate property checklist in the correct order so you know exactly what to expect and what to avoid. Immediately secure the probate property. Change the locks, collect the mail, notify utility companies, and cancel any unnecessary services. Vacant probate homes are targets for theft, vandalism, and insurance issues. So make sure you get in front of those risks immediately. Next, locate the will, if one exists, and obtain multiple certified copies of the death certificate. These documents are required to open probate, to deal with financial institutions, and eventually sell the home. Before anything is filed with the court, this is where families reach a fork in the road, because there's two different ways that you can start probate. Option one is hiring a probate attorney. The attorney will determine whether probate is required. He or she will prepare the probate petition, file it correctly, and will guide the legal process from day one. When an attorney is strongly recommended, this is usually the safest option when there's family conflicts or multiple heirs, if there's no will or questions about the will, if the estate includes real estate, debt, or business interests, or the personal representative just simply wants the protection and peace of mind. What's the trade-off? Well, the downside is cost. Attorney fees are paid directly from the estate, and they vary state by state. So it's important that you understand how those fees work. Most fees work on a statutory basis. But there's another option. Option two is handling probate pro per, which means without retaining an attorney. Now, this can work when the estate is simple and everyone involved is cooperative. Pro per may make sense when there's one primary asset like a single home. If all beneficiaries agree on the path forward, if the debts are minimal, and the personal representative is very organized and detail-oriented. Probate is paperwork heavy and time sensitive. One misnoticed or incorrect filing or one misunderstanding of authority can cause months of delays. Courts offer procedures and self-help resources, but they cannot give any legal advice. So if you go pro per, the responsibility still falls on you. So how do you decide? Here's the simplest way to decide which direction to go. If the estate is calm and straightforward, pro-per may work for you. But if the estate is complex or highly emotional, an attorney is usually the safest path. So ask yourself this: would you rather pay for expertise up front or pay for mistakes later? I recommend always look at hiring a probate attorney. But once you choose your path, the next step is filing the petition and formally opening the probate case. This is when probate legally begins. After probate is opened, the court appoints the personal representative. It's the executor if there's a will, or the administrator if there isn't a will. Until this appointment happens, no one has legal authority to sell the home. Selling a home in probate is a court-supervised legal process, not a traditional real estate sale. But when you understand the steps, the timelines, and all your options, you can avoid mistakes that are highly costly and avoid unnecessary stress. So if you're navigating probate right now, or think you may be soon, I've put together a free probate real estate sales kit to help you through the process. Inside, you'll find a step-by-step probate checklist, common mistakes families make and how you can avoid them, what to expect when selling a home during probate, and guidance to help you move forward with clarity and confidence. You can request this free kit right now by clicking the link in the description below. It's free and there's no obligation. Just clear, practical information to help you make smart decisions during this very difficult time. And if this video was helpful, please give it a like and share it with someone who may also need it. And make sure you subscribe to this channel for more probate real estate advice and guidance. But for now, thank you for watching, and I'm looking forward to seeing you in the next video.